So it's time to talk about Albright v. Oliver. The Albright v. Oliver decision of 1994. This comes out of Illinois. This has to do with qualified immunity, preliminary hearings, grand juries. And what you have is a corrupt cop and a corrupt lying witness. And a pathologically lying witness who had lied 50 times. Literally 50 times. And the cop is going to make 50 arrests, and the court is going to make 50 dismissals. 50 of them. Albright v. Oliver, 1994 decision may be used to claim a couple things. Number one, that a Section 1983 relief for prosecution without probable cause is only valid if the prosecuted party claims Fourth Amendment violations. Number two, that substantive due process does not guarantee non-interference by criminal investigations. Number three, that star players are immune but not supporting actors. That's insane. So we're going to let the kingpin get away with all their crimes, but all the underlings do not. Cocaine dealers, the star players, right? That's the kingpin. So we're going to let them do their thing, but the administrators and the runners, all their clerks and their underlings, the supporting players, this has to do with immunity. So if we're going to give the legislators immunity and the executive branch and the judicial branch, we're only going to give the star players immunity. Everybody else gets qualified immunity if they get any immunity at all. Number four, that the petitioner asks us to recognize a substantive right under the Due Process Clause of the 14th Amendment to be free from criminal prosecution except upon probable cause. No way. Nope, they're not going to do that. Number five, that the district court dismissed it because of qualified immunity and for witness immunity. But honestly, this is a perfect case that you want them to cite. So let's get into the details. The facts matter. So you have a cop named Oliver, right? Albright v. Oliver. And it's Kevin Albright, and I don't know the Oliver's name, but Oliver the cop. Now he's going to listen to Veda Moore. And Veda Moore is a compulsive and pathological liar 50 times prior. 50 arrests, 50 lies, 50 arrests, and 50 dismissals. Oliver gets a grand jury indictment based on hearsay of a third party. A grand jury indictment based upon hearsay. And Veda Moore, the liar, and it's a cocaine addict, right? So this cop, Oliver, is paying money to a cocaine addict. And the cocaine addict keeps on saying this person's guilty, that person is guilty, and this person is guilty. And the courts keep chucking the case out. Now at first you're going to have this grand jury indictment that says that it's John Albright Jr. But he goes and talks to John Albright Jr. No, now it's for John David. So they erase the grand jury indictment, the name on it, and they write John David. Well, then they talk to John David, and well, he's clearly not the person either. Then they go back to John Albright Jr. and they say, well, could it be somebody else? And he mentions he's got another son, Kevin Albright. So Cop Oliver, I don't understand what the hell he is doing. How does he not have a come-to-God moment? He was either giving Veda Moore state cash so Veda Moore could continue to snort her cocaine while he was having sex with her, or he's just the stupidest cop on the goddamn planet. You know, maybe after 6 lies, after 6 times of going out there, making the arrest and getting it dismissed, you would have, you know, a come-to-God moment. You'd be like, wait a second. Is this cocaine whore lying to me? And then why would the damn cop precinct keep him on? And why would the courts keep on rubber stamping everything that this cop Oliver keeps on saying? So the cop Oliver changes the grand jury indictment first to reflect John David's name and then Kevin Albright's name. Technically, justice was already meted out. So here's the accusation, right? They're going to say later on it was like she just opened up a telephone book and pointed to a name. Now Veda Moore said she had bought cocaine from John Albright Jr., who's an elderly, respectable man. He's a retired pharmacist. But instead of giving her cocaine, John Albright Jr. had sold her baking soda instead. Well, shit. Cop Oliver, for the 51st time, he's going to believe that liar. He's going to go ahead and believe her. And then, oh, you bought baking soda from somebody? Well, we better go arrest that person who sold you baking soda. At a preliminary hearing, respondent Oliver testified that the petitioner sold the look-alike substance to Veda Moore, and the court found probable cause to bind the petitioner over for trial. What fucking probable cause could they have had? Did you have a video? Did you have a photograph? Do you have any other witnesses besides this compulsive, pathological liar? At a later pretrial hearing, the court dismissed the criminal action against the petitioner on the ground that the charge did not state an offense under Illinois law. So it's not even illegal. It's not even illegal. I think justice was already meted out. You're going around asking people for cocaine and somebody sold you baking soda instead? Serves you right. Why the hell are you going around asking for cocaine from people? What are you, some sort of snitch? What are you, some sort of narc? At a later pretrial hearing, the court dismissed the criminal action because there is no Illinois statute that says you're not allowed. Hey, wait a second. You made a contract to sell her cocaine and instead you sold her baking soda? Get in the paddy wagon. How are they not criminals? Veda Moore asked for cocaine. She got baking soda instead. That's justice. That's justice. If we presume justice to be eye for an eye, stripe for stripe, fracture for fracture. The district court also held that Mr. Oliver the GOAT, was entitled to a defense of qualified immunity and that the complaint failed to allege facts sufficient to support municipal liability against the city of Macomb. The district court also dismissed without prejudice the common law claim of malicious prosecution against the cop Oliver. What? How is that not malicious prosecution? How did his constitutional rights not get taken away from him? Section 1983 is not itself a source of substantive rights, but merely provides a method for vindicating federal rights elsewhere conferred. Baker v. McClellan, 1979, such as the 14th Amendment. The first step in any such claim is to identify the specific constitutional right allegedly infringed. Graham v. Connor, 1989, and Baker v. McClellan, Supra. First, you have the false arrest. That was supposed to be a Fourth Amendment domain. Oh, you made a false arrest? Well, you have to say, well, 1983, then 14th Amendment, then Fourth Amendment. You got to have that 3 steps. And then if you want to say it's a malicious prosecution, well, you got to go through the Fifth Amendment. You got to go through the Fifth Amendment in order to get a malicious prosecution claim. Under Kevin Albright's substantive due process theory, the star player is exonerated, but the supporting actor is not. This is Ruth Bader Ginsburg saying all this. This is a 7-2 decision, and Stevens and Blackmun are going to make a dissent. And frankly, when you have a Bell v. Book kind of decision, Plessy versus Ferguson, when you have a Dred Scott decision, which is clearly bullshit and clearly wrong, those who make the dissent have the holding. So Stevens and Blackmun's dissent is the holding that makes sense in Albright v. Oliver, 1994. So rational law dictates that Stevens and Blackmun's dissent is the true holding. It's perfectly clear that the probable cause requirement was not satisfied in the 1994 Albright v. Oliver decision. You didn't have probable cause because you took the word of a fucking liar, and that fucking liar bared false witness. And if you got 2 people, one person bearing false witness and another person that they fingered, well, then that's only 2 people. And the presumption of innocence means that you have to go to the side of the presumption of innocence. Therefore, Kevin Albright has the presumption of innocence. Kevin Albright gets to walk. You got a liar lying, and then the presumption of innocence, you have they're competing claims. How can you believe one over the other? You can't believe one over the other. So, because Kevin Albright said that he did not do it, the Fifth Amendment to the Constitution constrains the power of the federal government to accuse a citizen of an infamous crime. Under that amendment, no accusation may issue except on a grand jury determination that there's probable cause to support the accusation. The question presented by this case is whether the due process clause of the 14th Amendment imposes any comparable constraint on state governments. You say that that person sold you baking soda instead of cocaine, and he says, man, I've never seen you. I don't know who the hell you are. You're making this entire shit up. You only have two people. They have competing narratives. And since Kevin Albright has the presumption of innocence, then the scales of justice, the balance goes towards him. The balance weighs towards the accused. As the Court of Appeals correctly concluded, the commencement of a serious criminal proceeding on such scanty grounds was nothing short of shocking. It was shocking. The cop, Oliver, his only evidence against the petitioner came from a paid informant who established her unreliability on more than 50 occasions. 50 occasions. 1974, U.S. v. Calandra. In U.S. v. Calandra, 1974, no person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia when in the actual service of war or public danger. So, more on Oliver v. Albright, 1994.